is an evidentiary hearing before the Indiana Utility Regulatory Commission in a cause docketed before the Commission as cause number 46309, and that's captioned as Appeal by Citizens Gas of Consumer Affairs Division Informal Decision in CAD Complaint number 138830, filed by Shirley Murray concerning a dispute over leak investigation. Notice of time and place of this hearing was given as provided by law by publication in Marion County's Indianapolis Star on December 6, 2025. This is a newspaper of general circulation, and a publication was made at least 10 days prior to the date of this hearing. The proof of publication of this notice has been received by the Commission and is now incorporated into the record of this cause by reference and placed in the official files of the Commission. Notice has also been given to the Indiana Office of Utility Consumer Counselor and other interested parties. So now we're going to go ahead and enter appearances, and appearing on behalf of Appellee Citizens Gas.
Your Honor, Alejandro Valle, Citizens Gas, 2020 North Meridian Street, Indianapolis.
Thank you, Mr. Valle. And for the appellant appearing on her own behalf, please just introduce yourself for the record.
Shirley Murray, 33rd and Denny Street.
Thank you, Ms. Murray. And for the public?
Yes, Your Honor. Appearing on behalf of the public, Adam Cashin of the Indiana Office of Utility Consumer Counselor.
All right. Thank you, Mr. Cashin. And this is your appeal, Mr. Valle, so we'll go ahead and let you begin your oral argument.
Thank you, Judge Gorman, Commissioner Merletta. Appreciate you guys taking the time to listen to this appeal. As we all know, this is an appeal from a Consumer Affairs Division informal determination. As I understand it, the CAD record has been prepared and is marked IURC Exhibit A, and that's what we will be referring to when we do refer to the record. The case here, I want to make clear from the okay. I certainly have no objection.
No objection from the public.
Oh, you're fine. Thank you very much. I do want to make clear from the very outset, we take no issue with Ms. Murray here, our customer. She has every right, of course, to present a complaint if she feels that that's appropriate. We don't think that she's done anything improper or inappropriate. Our concern really is with the Consumer Affairs Division itself and the way it has approached this investigation. The facts of the case, and I want to emphasize facts because that's a central component of our appeal, making sure that the record is factual and accurate. The factual background is actually pretty straightforward. Ms. Murray's complaint centers, as I understand it, mostly around reporting gas leaks or gas smell to Citizens Gas, and she has concerns with the way that was responded to by Citizens Gas. That's the primary focus of her complaint. At some point, she had reported this gas smell to Citizens Gas. We came out. Initially, we shut off gas because it wasn't safe at that point. There was a leak somewhere in the system. There is some slight disagreement, not really pertinent to our argument, but some disagreement. I believe Ms. Shirley thinks that the leak was on our side, the Citizens utility side of the infrastructure. We believe the gas leak was on her side. I don't think there's a need to resolve that dispute. The bottom line is that the leak was repaired or addressed, And at that point, we came out and we reconnected service. And that happened on the 29th of November, 2024. We reconnected service. At some point later that day, after our tech had already tested the line and reconnected service and left, Ms. Murray began smelling gas again. And so we went back out. It ended up being November 30 by the time we got out. And turns out that there was a swivel nut loose in the setting that was tightened up, and that addressed the issue. The key factual point that I think undergirded the CAD analyst determination was a misunderstanding that there had been a gas meter replacement that Citizens Gas had replaced shortly before this incident, or shortly before the reconnection that I just described. So October of 2024, the facts as she understood them or he understood them were that we had replaced the gas meter in October, and then we reconnected service in November, and the leak that was smelled later that day drew the conclusion from the analyst that we had reconnected service to an improper, not safe connection. The actual primary complaint that Ms. Murray had, which was lack of responsiveness, was found unsubstantiated by the analyst. Obviously, we take no issue with that portion of her ruling. She found that when we received complaints and notices, we responded promptly and appropriately. Where she found that there was a substantiation of a complaint was, again, the conclusion that we had reconnected service to a fixture that was not prepared to accept that connection. And I think the leap, the logical leap is that the leak that was there on the 30th that we addressed by tightening the swivel nut was also there on the 29th. And I think that is obviously Ms. Murray has the burden of proof as a complainant. Preponderance of the evidence, I think it's a reasonable conclusion to say, okay, Citizens, you put the meter in, you replaced it. Shortly after that, you reconnected service. There was still a leak. It was the swivel nut. I think it's a logical conclusion that those things are all related. Here's the key, though. When we received the analyst's determination that reached that conclusion, we realized that we had made an error in the factual recitation that we had provided. We had, and as Your Honor probably knows, we own and operate a number of different utilities. For some reason, when we were responding to the CAD analyst questions, at some point, this October meter change was misunderstood to be a gas meter. It turns out that that was a water meter, completely unrelated to the leak, the gas leak, completely unrelated to any of the issues that underlie the complaint here. So we immediately, the analyst's decision came out, and it's attachment 30 in the CAD record. It's clear from the CAD record that this gas replacement that the analyst believed happened in October, it's clear from her decision that that was central to her ruling. Again, going back to attachment 30, he says, October 10th, quote, October 10th, 2024, Citizens returned to replace the meter, again, the gas meter, and correct several worn parts of the house side of the meter connection. Later, he says, quote, given that this meter was replaced and checked for service readiness on October 10th, 2024, it appears the utility restarted gas service on a connection unfit for gas delivery. Again, that's the factual misunderstanding that I explained, that it's understandable that the analyst had that conclusion because of the information that he had in front of him. So her decision came out June 19th. Within the 7-day window that we have to appeal to the director, by June 25th of 2025, we had appealed to the director, indicating at that time, and again, this is in the CAD record, attachment 32, we indicated with our original request that there was a factual error and that we intended to submit material to correct that, that this was a water meter and not a gas meter. And then on the 3rd, a few days later, we followed up with a more detailed description of the records that showed, yes, this was a water meter. It did not involve the gas meter at all. And that additional information we provided is in the CAD record attachment 35. It's interesting because the CAD record shows, even though the CAD director found that this additional information was, quote, inadmissible, it does show that she confirmed the fact that we had alleged or clarified that this was a water meter and not a gas meter. Attachment 36 notes from the CAD director. She says, quote, reviewed the customer's billing statements attached to see if the statements indicated a gas meter exchange. The statements do not indicate a change to the gas meter. It appears that the gas meter mentioned in the complaint is still installed at the customer's premises. Even though she had reached that conclusion herself, nevertheless, on September 24, when she issued her director's decision, which is attachment 41 in the CAD record, she continued to substantiate the complaint regarding connection of service to an unfit connection. She notes in her determination, again, September 24th, 2025, attachment 41, she says, it's worth noting that 170 Indiana Administrative Code 16-1-5D states, and she quotes the rule, and I have the rule right here. It's not very long. This is all that subdivision says. Quote, if a customer or utility is dissatisfied with the Consumer Affairs resolution of the informal complaint, either party may request a review by the Director of Consumer Affairs or the Director's designee within 7 days of the date of receipt of the proposed resolution of the informal complaint. That is the entirety of what that rule says. Despite that, the Director took the position that because we had submitted this information after the analyst had made their decision, that she was not able to consider that. Again, the rule does not say that, but she claimed in her ruling, quote, the director's review is limited to the information provided to the analyst and the analyst's decision. So again, she claimed that the rule does not permit submission of additional information after the analyst makes a conclusion. Now, I do want to point out that the CAD record, which has been admitted here as Exhibit 1, was posted by the commission on its public site. It has everything from when the complaint was made, through the analyst's investigation, through the appeal to the director, through the director's investigation and conclusion. It even has our appeal to the commission. So basically everything from the beginning of the claim until it's presented to the full commission is considered the CAD record, at least according to the commission's website. The CAD record is continuously being compiled at that point. So it doesn't seem to be correct, at least under the law, that the director is not allowed to receive additional information from the parties after the analyst's review is complete. Now, it's certainly possible that they being the director, they being CAD, that they have a practice or maybe an informal understanding that once the analyst has reviewed information, that's what the director's gonna focus their decision on. If that's the case, the proper course would have been to reopen the analyst's investigation. That's something that's been done on a number of occasions. We cited one of those cases in our brief, cause number 46160. There's another more recent example, CAD complaint number 139036. These are both situations where a complainant's complaint was found to be unsubstantiated. The complainant appealed to the director within the 7 days, and at some point, sometimes several months after the appeal, the director determined that the analyst's investigation would be reopened, and that additional factual material was allowed at that point. So even though the law does not require a director to disregard new evidence submitted to it after the analyst's determination. Even if that was the practice of the CAD, it should have resulted in reopening of the analyst's determination when we pointed out this was not a gas meter, it was a water meter. And really all we were trying to do was correct the record. After all, the statute provides that the commission is a fact-finding body. Its charge is to make rulings based on facts impartially found by it. In this instance, the analyst was perfectly within her or his scope to reach the conclusion that he did, but the facts were different. And as soon as we picked up on the fact that the facts were not reflected accurately, we tried to correct that. It was ruled inadmissible by the director without any real basis in law. The analyst's investigation was not reopened, and so we have this now doubly substantiated finding that we had improperly connected gas service. It's interesting in the director's order or determination, there's a blank line that's supposed to contain the specific rule or regulation that was violated by the utility. That blank is left blank, and of course that makes sense because we did not actually violate any regulations. The director herself knew that based on her own investigation of the file, but she nevertheless did substantiate, again, the analyst's conclusion. So what we're asking the commission is quite simply to take a look at the CAD record as it's been compiled from the beginning through the appeal to the commission, overturn the director's determination showing that we had improperly connected gas service, or at a minimum, if case needs to go back to the analyst and be reopened and allow the additional factual information to come in. I mean, that's fine too, but we cannot let this factually incorrect rulings stand as the actual facts. You know, we've been around for a long time, 140 years maybe, here in Indianapolis. We take our safety record very seriously. It's one of the better records locally in the state, and it's a serious allegation that we connected service to a fitting that was not fit to receive that service. So we couldn't let this go. You know, I've been at Citizens for maybe 10 years. I don't know that we've ever appealed a CAD determination, whether it was substantiated or not. It's the first one that I remember doing. But this one we thought stood out and really needed to be addressed because we couldn't let the record stand the way that it was. So that's really the extent of our argument. We also have a brief that we submitted, but I think that covers kind of our approach here.
Thank you, Mr. Valle. Ms. Murray, if you can press that green light and speak into that microphone, now is your opportunity to present your arguments as to, in support of your position.
I feel like I've been living in unsafe conditions. He never mentioned that Peterman Brothers, I called a plumber into my home so they can inspect the inside of my home, and they found no leak inside my home. The last time the gas company was out to my house, it was December the 7th of 25. My brother-in-law called me, and he said, "What's going on?" I said, "I keep smelling something." So he came over, and he went straight. He said he smelled gas coming up the driveway. He went straight to that meter, and he showed me. He called the gas company, and they came out and wrapped it with something. But when I first started smelling that gas was in June. I work in the yard a lot, and I smelled that gas, and I called him. And he said, "You're right. It is a gas leak out here, Miss Murray." So he mopped it with something, which I don't know what it was. It was black, and he left. Somebody asked me, "Well, did they cut your gas off?" Not in June. They cut it off in July of 24. And it stayed off all the way from July to November 29th of 24, my son's birthday. Then they had to come back because over the neighborhood smelling gas because the scribble wasn't even tightened. So they came back and did that, but they did it the next day, not the day that they turned my gas on. But then I continue to smell, as of today, I continue to smell in my home. And I got Peterman's paper where I don't have a leak in my home. And when that man came out on December the 7th of 25, they seen that leak again, right there at that meter. And he said, I'm not leaving till the gas company comes, Shirley. So the gas company came, and they stood the whole time, and he showed them where it was, and that man wrapped it with some kind of white stuff, wrapped it. But as we speak now, if you go up to that meter, you can still smell gas coming from that meter. Peterman told me they said that wasn't a new meter in my home, but it is a new meter. Because he said if it ain't, I'm in the wrong profession. You have a new gas meter outside your home. But when I called and asked them, when did I get this meter? They gave me the date of the water meter, not a gas meter. My neighbor seen them come, exchange a meter, take a meter, exchange a meter. I wasn't home, but she seen them over there, and she seen them several times come to my home. And I feel that when they ask you to leave your home for unsafe conditions, my neighbor has a house real close to mine. Well, I feel she should have to leave too because it's unsafe conditions. And I've been paying Citizen Gas for over 30 years. I never had my gas disconnected for a bill or nothing. I'm too old for that. You know, I'm about my business, and I own that house over there at 33rd and Denny, and I never went through this problem ever. And I've been in the house over 30 years. I never had experienced what I'm experiencing now with the gas company. And I just feel since COVID has came and gone or still here, nothing's been done right. Nothing. And that's just the way I feel about it. But I have my documentations, I have stuff in my phone that supports my findings in the way I was treated with this gas. And if you go to my house right now, you can still smell gas coming from that meter. And it's not inside my home. And it's so rusted and bad that the man told me, well, you need to take something and scrape all this rust off. I said, that's not my responsibility to do that. I'm too old for that. But I do have all my documentations to support what I'm saying.
Thank you, Ms. Murray. Do you have anything else that you'd like to add as far as your position?
I just know I started smelling gas in my front yard in June. And then in July is when they cut my gas off. And it stayed off from July to November 29th. That's a long time to be in a house with no gas. And I'm totally gas, washing my clothes, cooking my food, you know. I'm total gas. So I suffered.
Well, thank you, Ms. Murray. I appreciate it. Mr. Cashin, does the public have anything to offer?
Your Honor, no, the public has nothing to offer at this time. Thank you.
Mr. Valle, back to you to wrap it up.
Just very briefly, Your Honor, totally understand Ms. Murray's frustration. As I sit here today, I'm not aware of any ongoing issues with gas at her home. But as I said before, we take no issue with Ms. Murray. We understand she's a homeowner concerned about her where she lives and her health. And if she believes that there's something wrong, then it's certainly within her right to pursue that. We've looked into it. We don't think there's an ongoing issue, but I certainly don't fault her for the way she feels, and I take no issue with the comments that she's made.
All right. Well, That is going to conclude today's hearing. We're going to take the oral arguments presented today and the CAD record in this case under advisement and review it, and the commission will going off the record. Back on the record, yes. The commission will take the oral arguments under advisement, and we will also review the CAD decision in light of the oral arguments presented today, and we will issue a decision. And we are adjourned. Thank you.